Hello everyone, welcome to another episode of Immigration for All presented by Noura Global. For today's session, I'm your host, 𝐬𝐬𝐴. You may already know that we have rebranded our popular Monday live series under this new banner. This session will also podcast in Spotify and Apple Podcast. For today's session, our topic is Athletes Immigration to the USA. Before we dive into today's topic, I would like to remind you that if you have any questions or comments, feel free to share them through the comment box. Without any delay, let's welcome our guest speaker, Mr. Raju Mahajan, the Principal Attorney of Raju Law.
Thank you very much, Margia. How are you doing this morning?
Hello, Mr. Mahajan. Thank you so much for joining us. How are you doing?
I'm good,
I hope
thank you.
You had a good day so far.
Yes, so far so good, yes.
Okay, Mr. Mahajan, can we proceed with today's topic?
Yes, thank you very much. Yeah, without further delay, I would like to talk about athletes' immigration to the United States. I would like to show the PowerPoint. Thank you very much. So as it says, we're going to talk about athletes' immigration to the US, and today is the part 1 because it's a big discussion. We will try to cover everything in our entire presentation, but today we're going to talk like half. So that's why it's part 1. Another Monday, we will talk about part 2. And I'll explain which part we're going to talk today, which part we're going to talk in next week. But before that, when I say athletes, I literally mean any kind of athletes. You can be let's say, soccer player, a cricket player, a rugby player, basketball, or running, or any kind of gymnastics or anything. So any kind of athletes, you will qualify under this presentation, and you have multiple different ways to immigrate to America. Some for long term, some for short term, and I'm going to explain everything today. So without further, let's go to the second slide. All right, and as I say every Monday, so this presentation we are live broadcasting in our YouTube, LinkedIn, and Facebook page. At the same time, the audio part we live broadcast in our platforms like Apple and Spotify as a podcast. So those who are listening to our audio, please do not worry about me talking about next slides, because anything that I show in our slides, I also say that verbally, so you do not actually miss anything. I try to cover that. If you watch our video, or if you listen to our audio, you'll not miss anything from our discussion. So athletes immigration, if I divide into the entire thing into 2 different parts, the first part is non-immigrant visas. And non-immigrant visas are like when you come to America for a specific purpose, for a specific time, and after your specific work is done, you will go back to your home country. That is called non-immigrant visa, meaning you're coming to America for a specific period, a short period, not to be a green card holder. And this is a legal requirement. So when you apply for a non-immigrant visa, like O1, O2, P1, P3 kind of visa, in the embassy, when the immigration officer will ask you what is your plan, you must mention that after performing this work, you're going back to your home country. This is a legal requirement. Please do not say that you intend to stay in America forever. You want to apply for a green card. Please do not say that. Then you violate the requirements for non-immigrant visa. So this is a very housekeeping kind of things. So so here we are going to talk about O1A, O2, P1. Let me actually tell the entire name so you'll understand. So these all are non-immigrant visas, and then after that I'm going to talk about immigrant visas, which is like green card applications. So O1A visas are for individuals with extraordinary ability in athletics. So if you want to apply for O1A, you have to show that you are a individual with extraordinary ability in your field. O2 visas are for essential support personnel for O1A athletes. So let's say Mr. X is a extraordinary ability athlete, and Mr. Y is a coach, or physiotherapist or trainer, or those kind of person, which is very essential for Mr. X to perform his work as a athlete. So O2 visas are for essential support personnels. Similarly, P1 visa is for internationally recognized athletes. So do you see the difference? O1A is for individuals with extraordinary ability, and P1A is for internationally recognized athletes. So these are the difference, and I'm going to talk about that in a minute, so you'll have a better understanding what is the difference between extraordinary ability and internationally recognized. Also, P1As is for essential support personnel for P1A athletes. So P1As and O2 are very similar. O2 visa holders support O1A visa holders, and P1S visa holders support P1A visa holders. So one is athlete and one is essential support personnel. So that's the difference between these two things. And P3 visa is for culturally unique program. This is another new thing. So let me say that again. So these are the beauty of law. When we lawyers, we work, we kind of play with words and its meanings and its interpretation. So O1A is for extraordinary ability athletes, P1A is for internationally recognized athletes, and P3 is for culturally unique athletes. So that's the difference. That's the beauty. That's why when we apply for any clients, we prepare a case for any clients to submit to USCIS, we have to remember these terms and we have to make sure that you qualify for these specific requirements. Next slide, please. All right, so this is also non-immigrants categories. J1 visa, exchange visitor program. That's another very unique category for international athletes to come to America, and then then you perform your game here, play a game here. Q1 visa, cultural exchange program also. So one is exchange visitor program, one is cultural exchange program. That's another very significant different thing. H2B visa, temporary non-agricultural worker. Everybody who is involved with the sports, those are like a non-agricultural worker. So H2B is also another category for you. B1, B2 is a visitor visa. However, once you come to America under a B1, B2 visa, you can play game. You can play game. However, the big requirement is while you are in B1, B2 visa, you cannot take any money. That's a big no. Please remember, once you are in America under a B1, B2 visa, you cannot make any money in any format. You cannot take any money from anybody. That's a big thing. Please remember that. By the way, this J1, Q1, H2B, B1, B2, we are not going to discuss detail today because we are kind of focusing on O1A, O2, P1, P3 kind of things. Also, today we are kind of like going over everything. So we are not going to go very deep about O1A, P3, P1. We will have a very separate video on every single visa categories, so that would be more in depth. Today we are kind of like trying to go over everything, because if I want to go detail about every category, then I have to talk like 3 hours, and I can talk 3 hours, but you will lose interest. That's why we'll try to complete our presentation within 15, 20, 30 minutes. So that's why we'll just go over everything, and then another day we'll talk detail. Next slide, please. All right, I just mentioned about all the non-immigrant categories. Now I'm going to talk about immigrant categories, meaning under these two categories, you can apply for green card as an international athlete. EB1A, extraordinary ability visa, EB2 NIW is national interest waiver visa program for international athletes. Again, I'm not going that detail today. This is for part 2. We'll talk about these another day, but I'm just telling you, in these two categories, if the US officer in the US embassy asks what is your future plan, then you can say, yes, I'm going to America, I'm going to stay there, I'm going to perform my job, I'll play games, and that's my plan. So when you apply for immigrant visa, you can say that you want to come to America to stay here. But when you apply for non-immigrant visa, you cannot say that. You have to say that I'm going there for a specific time. After doing my work and doing things, I am coming back to my home country. That's a big requirement. Next slide, please. All right. So now I'm going to talk about O1A visa, individuals with extraordinary ability in athletes. So to qualify for O1A visa, athletes must meet at least 3 of the 8 criteria. These criteria are, here are the criteria. Number 1, significant nationally or internationally recognized achievements, awards, or honor in their field. So to qualify for O1A, there are 8 criteria, and you have to meet at least 3. But I personally recommend meeting 4 or 5, because sometimes we say that you meet this criteria, and then USCIS officer will say, no, you do not meet this criteria. So even they deny 1 or 2, then if you have at least 3, let's so this say at least 3, then you will get the visa. That's why try to meet as many as possible. Do not just try to meet just 3 and then apply, because that will, in that case, your application will be a little risky. As I said, the first requirement is significant national or internationally recognized achievements, awards, honors in their field. Number 2 is membership in associations that require exceptional accomplishments as a prerequisite. So it's not just a simple membership to your organization. We have to establish that membership in this organization is itself is an achievement. Not everybody can qualify to be member of this organization. There are some prerequisite to be exceptional accomplishment to join that organization. So that's another thing. I'm not going into that detail, as I said, because that will take a long time. Published articles, profiles or features in prominent publications or media outlets highlighting the athlete's achievement. Basically, you have to have media coverage. So let's say a big newspaper, like a very renowned newspaper or television channel, or even YouTube channel. Nowadays a lot of YouTube channel has millions of subscriptions. So if they highlight something about you, that also qualifies as a published article or like a media coverage kind of things. Next slide, please. All right, so this is the continuation of the previous 8 requirements. I already mentioned 3. Number 4 is documentation of the athlete's role as a judge, referee, or panelist evaluating peers' performance in their field. You have been invited to judge the performance of another people. Number 5, significant contributions that have made a substantial impact on the athlete's sport. You have a substantial contribution in your field. Number 6, authorship of scholarly articles in reputable journals or media that demonstrates their expertise. So this is the field where most of the athletes, they suffer a lot. They say, hey, I'm an athlete, I'm not a researcher, I do not have a PhD degree. How do I publish scholarly articles? So the best way to do that, and I give this advice to all of my clients, and I'm giving it to you. So let's say you have a good friend, he is studying master's or PhD in sociology or social welfare kind of subjects, and you and your friend, you two publish a article about what is the impact of athletics on a society. Like athletics is really good for society. Young kids or adults, teen, when they play games, they are involved with athletics. It's good for their body, it's good for their psychology, and it also makes them happy. So there's a lot of social elements of athletics. So if you can publish a journal article as a co-author, so your friend who has a PhD or master's in sociology or social work, he or she will be the main author and you can be the co-author of the journal. In that way, you can actually meet this criteria. It's not that hard to be a co-author, right? So that's the way you meet this criteria. Again, high salary or remuneration compared to peers, signifying extraordinary ability. It's not that hard. Most of the athletes, most of the players, they make good money. So all you have to show that you make good money compared to your peers. That's the trick. Not compared to the random people, compared to your peers. So we have to show the comparison with other athletes in your industry, in your country. So we have to show that it's not that hard to do that. Participation in distinguished events, it's very easy. Like if you participate in Olympic Games or World Cup or international tournaments, some regional international tournaments, those will qualify for this. So those are the requirements for O1A. Next slide, please. All right, so petitioner requirement, one thing, all the non-immigrants categories that I mentioned, O1A, O2, P1, P1S, P3, you cannot apply by yourself. You must have an employer or agent in the United States who is going to apply for you. This is a big requirement. Sports persons, athletes, you cannot apply by yourself. So please remember that. A lot of time they call me, say, hey, I want to apply to come to America. And I said, do you have any employer or agent? They said, no, I don't. I said, you have to have an employer or agent, otherwise you cannot apply by yourself. So this is a big requirement. Please remember that. Period of stay. For O1A, up to 3 years to accomplish the specific event or activity. Additional time may be granted, increments of up to 1 year as required to complete ongoing activities. So in general, you will get a visa for 3 years. After that, if you apply for extension, they will keep extending your visa in 1 year increment as long as you need. Also, family members like a spouse and any unmarried children under the age of 21 may apply for O3 non-immigrant visa. So O1 visa holders dependents will apply for O3 non-immigrants visa, and the requirements are pretty simple. All they have to show that their spouse or children of you, and if you meet the criteria, they will also meet the criteria. That is the requirement for O1. O1 is dependents, O3 visa holders. Next slide, please. All right, now we're going to talk about O2 visa, essential support personnel for O1 athletes. So, individuals who provide critical support to O1 athletes, such as coaches, trainers, or other team members whose skills are integral to the athlete's performance. This integral part is very important, very tricky. When we work, we have to pay special attention to this integral part. Some of the support staffs are not that integral part, so in that case we cannot apply for O2 visa for those people. So let's go through what are the qualification to meet this requirement of integral. To qualify for an O2 visa, applicant must demonstrate that their role is essential to the athlete's performance. The following criteria apply. Number one, the individual must provide essential services related to the O1 athlete's performance. Number two, the individual must have specialized knowledge or skill crucial to the O1 athlete's success. For example, trainers, coaches, physicians. So if you do not have a specialized knowledge, let's say you are saying that, hey, I'm a physician, I'm going to go to America to help O1 athlete, Mr. X. And if you do not have specialized knowledge as a physician, how do you apply for O2, right? So you must have essential knowledge in that field to provide essential support to O1A visa holders. Next slide, please. All right, O2, continue. Number three requirements are documentation showing a prior working relationship with the O1A athletes, for example, previous competitions or training sessions. So, this is another very important thing. In legal world, we cannot say anything without documents. Evidence is key to success for any cases, no matter immigration, family law, business, international trade, you name it. For any kind of case, evidence is very important. So no matter what you say in your petition, you must have supporting evidence, supporting documents to support your claim, right? So a lot of our clients, they say, hey, I will do this, and I say, can you give us some evidence or document? They say, I don't have any. So without any evidence or document, it's really hard for us to work as an attorney. Also, petitioner, payoff stay, or family members will follow the same requirements like O1A. It just, you have to show that you're supporting O1A stuffs. All right, we are going to the next slide. Now we are going to talk about P1A visa, internationally recognized athletes. In P1A application, we really need to pay attention to the part internationally recognized. No matter how genius, how great athletes you are in your home country, if you cannot show evidence of international recognition, then it will be very difficult for you to get P1A visa. Now, a lot of my clients, they say that, hey, I never been to America, I never been to any other country, I never been performed any game in an international level, but I'm a really great athlete. I have a lot of national awards and blah blah blah. What I do? So in that case, the suggestion I give them: come to America with a B1B2 visa. It's very easy to come to America with a B1B2 visa. I mean, of course, you have to get the visa. Then you perform some games here in America or some other international countries. And of course, as a B1B2 holder, you cannot take any money. That's totally okay. You will do it free, but that will give you some international recognition, right? Like, for example, you are from India, you are a cricket player, you're from India, you're coming to America to participate in a game, but as a B1B2 holder, you cannot take any money, you will not take money, but you will just play the game in a voluntary basis. That will give you some international recognition. Then you qualify for P1A, and then you apply for P1A, right? So this is the strategy that I tell my clients, and I'm going to also tell you to that. So by the way, so the description of P1A visa is: this is for athletes or teams with a significant level of international recognition who are coming to the United States to participate in a specific athletic competition or event, Who can apply? Of course, internationally recognized individuals, athletes, or team. So this is another thing. You do not have to, you definitely can come to America as an individual person. At the same time, a whole team, let's say if it is a soccer team, a 11% team with all the supporting staff, probably 15-20% can come to America as a team. So that's also another beauty of P1A visa. Professional athletes, employed by a professional team or minor league team affiliated with a major sports association, for example, Ravens exceeding 10 million. So this is the requirement for you. This is the requirement for the employer. So if the employer's annual revenue exceeds 10 million, then the case is stronger. Of course, even if you make less than 10 million, that's okay. Sometime, we submitted application for whose revenue is not 10 million. We also got approved, but this is kind of like a general requirement. It makes your case stronger. Next slide, please. All right, amateur athletes or coaches, coming to perform as part of a team or franchisee from a foreign league meeting specific criteria. That's for like the amateur athletes or coaching stuff kind of things. General requirement: international recognition demonstrating a high level of accomplishments in their sport. Of course, contracts with a U.S. league or team for participation in athletic competitions. So this is another very good thing. If you have a contract with a U.S. team or a club, that will make your case really stronger. Sustained performance at a high level of competition. Of course, if you perform in a high level of competition, then your case would be stronger. Next slide, please. All right, so this is the requirement for the petitioner. As I said, all non-immigrant categories must have a agent or employer. Same thing here. Period of stay for P1A, the time needed to complete the event. So this is the difference between O1A and P1A. So for O1A, they will give you visa for 3 years. And for P1A, they will give you visa for only for the time you need to complete the event. So for example, for O1A, you will come to America for 3 years. And in general, usually you have an annual contract with your employer or agent. So let's say you were as I said, let's say you are a cricket player from India. You're coming to play game under a club and you have an annual contract and they're paying you annually. In that case, you'll qualify for O1A. At the same time, if you come to perform a specific event, let's say 2 months, 3 months kind of thing, that will not qualify for O1A. It will be P1A, and you'll get visa for only for the time of for the event, let's say for 3 months. That's why a lot of people, they like O1A because it's for longer period. However, it has like a higher requirements. P1A's requirements is comparatively less. So a lot of people also come to US under P1 categories. So as I said, the time needed to complete the event, competition, or performance. For an individual athlete, this period of time cannot exceed 5 years. Even though, if you say that the entire event or the entire performance will take 5 years, you cannot exceed 5 years, and 1 year for the athletic group. So if you come as a group, the maximum limit is 1 year, and if you come individual, it's like 5 years. Extension of a stay, of course, increments of up to 5 years for individual athletes and 1 year for athletic group to continue or complete the event, competition, or performance. Total stay is limited to 10 years for individual athletes. The total under P1A cannot exceed 10 years. So you have to kind of do something within this 10 years. Otherwise, you have to go back to your home country. All right, next slide, please. I'm trying to rush because I'm talking a lot. So family members of P1A, spouse and unmarried children under the age of 21 may apply for a P4 visa to accompany or join the athletes in the US. So P1A's dependents will apply for P4 visa. That's also another non-immigrant visa. And of course, you have to say that after staying here, you will go back to your home country. Next slide, please. All right, now P1A visa, essential support personnel for P1A athletes. So for individuals who are, integral to the performance of P1A athletes or team, such as coaches, trainers, or, team staff, very similar like O2, we already discussed everything under O2. So, if you are interested to apply for P1S, please, go back and listen to our talk about O2. It's very similar. All you have to say that you're going to provide essential support to P1A athletes. That's it. Next slide, please. P3 visa, culturally unique programs. This is another very tricky part. Here you have to show cultural uniqueness. No matter how famous athlete you are, like for example, Lionel Messi, he is the the #1 in international soccer. but it would be very difficult for him to qualify for P3 visa because soccer is not culturally unique. It's worldwide. Every country plays soccer in a very same fashion. So I know Lionel Messi already has US green card. That's a different story. But if he did not have the US green card, if he applied for P3 visa, then he will not qualify for this because he's playing soccer. Similarly, cricket would be very difficult to get P3 visa because it's not culturally unique. It's a lot of folks all over the world they play. However, if you have a specific playing style, like one Sri Lankan bowler, I forget his name. His bowling action is very unique. It's very culturally unique. Then he will qualify for P3 visa. So to qualify for P3 visa, you have to show that you have a culturally unique background that will qualify you for P3 visa. All right. So for athletes participating in culturally unique programs such as traditional or indigenous sports and other events that promote cultural heritage, this visa is designed for athletes who are involved in showcasing or promoting their specific culture through athletic programs. To qualify for a P3 visa, athletes must meet the following criteria. The athlete must be coming to US to participate in a program or event that is culturally unique. These can include traditional or indigenous sports, cultural exhibition, or performance that showcase the athlete's heritage. Okay, next slide, please. The event or program must be documented as culturally significant with evidence that it represents an important cultural tradition or art form. The athlete must provide evidence that they are playing a key role in promoting or participating in the culturally unique event or program. As I said, this is like the same thing. Next slide, please. All three. So special consideration, the P3 visa is intended for cultural exhibitions or events rather than mainstream competitive sports league. It is commonly used for athletes involved in non-mainstream cultural competitions such as traditional wrestling, martial art, or indigenous games. As I said, mainstream games like cricket, soccer, basketball, in most cases, you will not qualify for P3. You have to go to other kind of games. The visa also applies to athletes participating in cultural exchange program or promoting cultural awareness through athletic events, of course. Next slide, please. Petitioner requirement, as I said, of course, you have to have a employer or agent in the United States like all other non-immigrant categories. Period of stay, the stay is limited to the time needed to complete the event, activity, or performance, not to extend 1 year, increments of up to 1 year to continue or complete the event, activity, or performance. So bottom line is not like O1. O1 will give you initially 3 years, and then you can, get extension for 1 year at a time. But for P3, you will only get visa for a limited time, the time you need to complete that event, and not more than 1 year total. All right, next slide, please. Thank you very much. So that was our presentation today. This is the first half. Next Monday or sometime later, we're going to talk about the second half, and together you will have a big picture idea of athletes' immigration to United States. Going back to Margia.
Thank you, Mr. Mahajan. Thank you so much for this presentation. Let me ask you a question. As you mentioned, all of these type of visa are non-immigrant. So at the end of the visa, can the athlete stay or apply for EB2 and IW based on what they did with what they done during their stay on visa?
Yes, thank you very much. So once someone in America with any non-immigrant categories, non-immigrant visa, they can always apply for immigrant visa. That would be a totally independent application. It has no connection with the non-immigrant visa, and they need to follow the requirement for the specific green card application they're following. So they have to follow that thing. These non-immigrant categories will not give them green card, but they can definitely apply for green cards if they qualify for the requirements.
Okay. Thank you, Mr. Mahajan, for answering my question.
There was
Thank
another
you,
question on
everyone.
the screen. Can you see the question again? Yes, it's Rafi Sharkar said, hello, good wishes. I want to know about the EB3 unskilled process in 2025. Will it be good for this current situation? The backlogs can clear in under Trump. Is it possible to get EB3 visa in 4 years? So, Margia, let me answer this question, and then if there's any other question, we'll go back. So, So this is kind of my prediction. Of course, nobody knows the future. So Donald Trump is saying that he's going to deport a lot of undocumented folks from America. And at this moment, there are more than 11 million undocumented people, and they are 4.5% of total US workforce. So if Donald Trump deports a significant number of folks from America, then there'll be huge shortage of workers here in America. Of course, if it happens, then there'll be huge shortage and EB3 will be expedited. That's kind of my prediction. I do not know. So probably EB3, will be done in 4 years, probably even less, like probably 3 years or less. I do not know. So all I will suggest you, keep your eyes open. There's a document called Visa Bulletin. Department of State publishes it every month. If you already applied for EB3 unskilled, I'm pretty sure you have a priority date. Please follow the priority date in Visa Bulletin. When you see that it's moved fast, then you can get ready for a shorter period. If you see that it is not moving fast, it is like kind of like staying in the same place, it is not moving fast, then probably it will not move fast. All I will say you that pay attention to Visa Bulletin, see how fast it's moving. But my prediction is that it will move fast, and probably you'll be done within 4 years. You'll be able to come to America.
Okay, thank you, Mr. Majan, for your valuable time. Dear audiences, thank you so much for attending. Next week, we have another live session during the same time, which is 11 Eastern Time and 10 p.m. Bangladesh time. Till then, have a great week. Before we wrap up, we would like to give a quick glance to the major immigration news of this week.
Welcome to the latest episode of Weekly Immigration News by Raju Law. This week, we brought to you 4 latest developments in the immigration arena. Let's start with the headlines. Federal judge temporarily blocks Trump's birthright citizenship order. USCIS waives COVID-19 vaccination requirement. Special passport acceptance fairs. Trump officials shut down Latin America immigration offices. Let's get into details. On January 23, a federal judge temporarily halted President Donald Trump's executive order aimed at ending birthright citizenship, labeling the policy as blatantly unconstitutional. The order, which seeks to revoke automatic citizenship for children born in the U.S. to non-citizen parents, has spurred numerous lawsuits nationwide. U.S. District Judge John Cogner, appointed by Ronald Reagan, oversaw the initial hearing in a lawsuit spanning 4 states that challenges the executive order. Next up, effective January 22, 2025, USCIS announced it will no longer require adjustment of status applicants to provide proof of COVID-19 vaccination on Form I-693, Report of Immigration, Medical Examination and Vaccination Record. USCIS will not issue requests for evidence, notices of intent to deny, or deny applications solely due to the absence of COVID-19 vaccination documentation. This policy applies to all adjustment of status cases moving forward. Moving on, the U.S. Department of State offers special passport acceptance fairs for first-time applicants and children applying in person using Form TS11. Adults eligible to renew with Form TS82 can apply online or by mail anytime. These events are held on evenings and weekends, with an updated list of events available monthly. Facilities offer routine and expedited service but do not issue passports directly, mailing applications to the Department of State. For urgent travel within 2 weeks, appointments can be made at one of 26 passport agencies or centers. Finally, the Trump administration is closing Safe Mobility Initiative offices in Latin America, set up by Biden to offer legal immigration options and reduce illegal border crossings. Located in Colombia, Costa Rica, Ecuador, and Guatemala, these offices allowed migrants to apply for legal U.S. entry. The shutdown is part of a broader effort to reassess U.S. migration policies and align them with national interests, and follows President Trump's executive order suspending the U.S. refugee admissions program.